Welcome everybody to this session of the Mishcon Academy. For those joining for the first time, the Academy is our series of talks hosted by Mishcon Durea, looking at the biggest issues facing society today. And I'm absolutely delighted to have Monica Feria-tinta here today as our guest. Before I introduce her properly, quick word about who I am and why the hell I'm here. I'm Laurie Doering. I'm a managing associate at Mishcons in our firm's sustainability and human rights practice called Mishcon Purpose. Just two quick housekeeping points, please. The first is that if you're online, you've joined on mute automatically with your camera off, so no worries there. There'll be some time for questions at the end. If you're online, please use the Q&A function at the bottom of your screen. If you're in the room, please raise your hand. Thank you. Monica. Monica Feria-tinta is the author of this beautiful book, A Barrister for the Earth, 10 Cases of Hope for Our Future, which was published by Faber in 2025 and has been shortlisted for the Westminster Book Awards 2026, which is the award for best political writing, voted on by sitting members of Parliament. So very good luck for that. Monica is a barrister at 20 Essex, where she specialises in all aspects of public international law, acting both as counsel and as arbitrator in international arbitrations. She was finalist for Barrister of the Year in the Lawyer Awards 2025 and was Woman of the Year at the Women and Diversity in Law Awards 2025. So a star-studded CV, that's just the top of that's just the latest of your achievements. And she's been referred to as one of Britain's most dazzling legal minds. I'll do a very abbreviated version of your CV, if I may, because it is a fascinating one. You were born in Lima, in Peru, where you studied law. You did your undergraduate degree there. And then you came to London in your 20s as a refugee.
Yes.
You were fleeing the bloody civil war in Peru and the dictatorship there. And you came and did an LLM, did some postgraduate studies at the London School of Economics, just down the road from here. This was followed by further training across Europe in all areas of public international law, in Geneva, Strasbourg, Hamburg, and Finland. And you then started your legal practice in the international courts, first at the International Criminal Tribunal for former Yugoslavia, and then at the ICJ, the International Court of Justice. In 2014, you were called to the bar. Mm-hmm. And according to Wikipedia, you were the first Latin American to be called to the bar in England and Wales. I just wanted to check if that's right, because it made me feel very parochial.
It is right.
Astonishing. Now, as a barrister, you've had many, many successes. I just want to highlight one. You made legal history in 2022 when, with the Torres Strait Islanders case before the UN Human Rights Council.
Committee.
The UN Human Rights Committee, thank you, which was the first recognition by an international judicial body of the applicability of human rights law to the issue of climate change. And the thinking that you applied in that case sort of laid the groundwork for doctrinal developments that were later adopted by other tribunals, including ITLOS and the ICJ. A Barrister for the Earth is your first book, and it's made a splash way beyond legal circles. You've been featured on the BBC Private Passions, where you shared your favourite playlists, and you've featured in British Vogue. So this is more than most of us can aspire to in several lifetimes. So, and that's just the abbreviated version. Monica, welcome. Thank you for joining us. Following on from that last point, I wondered, you wrote this book in a way that is really accessible to the general public, and it makes the issues of international law and the rights of nature accessible to a wider public. Why is it that you wanted to do that?
So this was not the first book I wrote. I have written legal books, but this was the first book that I wrote for a general public. And I think what made me write the book was really anger, because I had been, my practice is very broad, as you have mentioned, but I had been developing a practice on environmental law since the beginning of my coming to the bar. I worked for a little while during my pupillage in a case that concerned group litigation in the technology court here in England. And it was against BP. It was a very, very sophisticated case that was in court for 5 months. So this really opened my eyes to very sophisticated ways of dispute resolution. Here was against a particular company, but it was amazing to me that you could resolve disputes in England using applicable law from Colombia, for example. So that was completely new for me, and it really showed me how it was possible to perhaps engage with justice processes, in a number of ways, and how the common law permitted all of that. So after a while practicing in environmental law, and I pick up 10 stories in the book, I had the experience of working in a particular case concerning a coal mine in Colombia. And by then we already had the Paris Agreement, which many of you know that is being really a key instrument to address climate change. But back then, nobody really thought that we could do something beyond the meetings that the states had in Paris, so post-Paris. And everything was just at the diplomatic level. So what is interesting is that the first people that were interested in what to do with it was not really NGOs, was not really sectors that came from, it was the business sector. So I was approached by the arbitral community. I was approached in 2015 by the PCA, by the ICC, by the Stockholm Chamber of Commerce, who invited me to deliver a paper and discuss the possibilities of enforcing the Paris Agreement, whether it was possible to enforce that via other mechanisms, including arbitration. That is what set me into that kind of question of, is this possible? And so the book tells a little bit about the journey, because I wanted the average person to realize how powerful the law was. When I started thinking about this, I never thought what would be the path. But eventually, when I realized how the law was so malleable and so able to respond to new challenges, that I felt that this had to be shared with a wider public than just lawyers. So that's how the book came about.
And the issue that you pick up, which is a wider issue, really, is, has the law lost its path at some point by becoming too focused on humans and human rights at the expense of the wider rights of nature? And you asked the question, could there be a paradigm shift from an anthropocentric approach to law to an ecocentric one? What do you mean by that?
Yeah, so that is a fundamental question here in the book. I had never thought before about how anthropocentric our law was. I don't know how many of you have ever stopped to consider that, but I hadn't. So I want to actually state at the outset, I was never a campaigner, or I was never even someone particularly conscientious about green issues ever in my life. And I'm quite honest in the book when I speak about my background when it comes to completely oblivious about lots of things, and how my work actually helped me to discover a lot about our the connections, and how complex, really globally, the whole issue of environmental matters are. And I think that, I mean, really to think about how the law has moved, I apply a little bit of my knowledge on international law. I realize when I worked on the Torres Strait case that something massive was happening. So just before the Torres Strait, there has been a case in the Americas, and it was by the Inuits in 2005, which went nowhere. So basically everything was melting. And I read the actual petition that was very well drafted, about 150 pages, and it went nowhere. It was not even registered. And I read that very carefully and studied that very carefully because to me this was all very new back then. And I realized that what were the gaps. And I really wanted to crack the code as to what kind of approach will make a case like this win. Because what I realized is that the melting of the ice of the Inuits was directly connected with the sea level rise that my clients, years later, were experiencing. So I guess what you can see there is that it was a matter of really step back and consider carefully whether the law was able to give a solution, you know, to something like that. So that's something that really set me on that path to reassess what was happening and to reassess the instruments that we had available. So I think that was just the beginning of something really big to come later.
So the legal problem with the Torres Strait Islands, if you could just bring us into that back in time.
Sure.
Your clients were First Nation Australians.
Yes.
Living on a string of islands between the north coast of Australia and Indonesia. And what was their problem?
So the problem was that the islands were sinking. There were different islands, and each island has specificities. They were all different. But what was happening is that this was actually something that they've been raising. They went to the government, they tried, you know, to get the attention. And the first probably petition was that the erosion of the sea level was really going very, very quickly, was affecting everything that they knew in the island from really, they have, for example, gardens that would disappear. And they actually described the islands like going clockwise, you know, moving. And now I didn't understand that. And I thought when I read their statements, is this real? But when I went to Germany, to the island of Sylt, I realized that, this happens. So the sand has to be stabilized. And it was stabilized in Germany with certain techniques, for example, growing certain plants that could actually make sure that with the erosion, the sand wouldn't just go and the island wouldn't move in the way it was happening in Torres Strait. So in the Torres Strait, they didn't have any measure. They were trying to get the government to do something about it already for 10 years by the time that I was instructed in the case. So it would appear that the only thing to do was to bring a claim, so to get accountability for inaction. And something to remark in this particular case, it was not about just the land. So as an international lawyer, the way you look at islands is that islands fundamentally are connected to the sea. You'd never see them just as territory. Part of the territory is the maritime territorial aspects of it that are connected to the island. So for the Torres Strait Islanders, the sea was part of the ancestral territory. And a lot of species that were living in that territory were disappearing. And everything was changing. So they couldn't tell anymore the weather. That's how they put it. So this was it. I mean, this was the first case that started making me understand how rapidly nature was, deteriorating together with the life that we human beings connected to the land. were experiencing. So at no point the Torres Strait Islanders felt separate from the land, or they actually felt that this was, they couldn't be alive and have a normal life if they were to move somewhere else. They were deeply connected to that particular ancestral territory. And that was the peculiarity of that case. So that you couldn't just, well, why don't we just take them to Ireland B? No, because all the very identity and dignity was connected to that place. So this really started to teach me about issues of how rapidly the natural world was being affected negatively. And then later, when I was involved in the Ecuadorian case, the Los Cedros case, I started thinking more clearly about the limitations of an anthropocentric perspective of the law. So you asked me before, what is it? So all our laws have been thought from the perspective of human beings. How that benefits us or protects us, etc. But that has a limitation. And the way I saw that is that in a big crisis like last century, when we had crimes against humanity at a level that we hadn't ever experienced in the world with the Holocaust, there was this clear understanding that life needed to be protected. And we had all these fantastic instruments, human rights instruments, that were adopted, and that was good. But at the same time, I felt that there was a limit here, because the way life was protected was as the life of human beings. So it's the right to life of human beings. So when I read all these instruments, I could see that there was no mentioning to the environment or the natural world. So basically, the law protected us as human beings in the conception that human beings didn't need any of that in some kind of vacuum. So now, I realized that. And environmental law started developing much later, as soft law only, during the 70s and onwards. And it was still looking at nature from a perspective of resources. I hate that word, really. And at some point in 1982, we had a charter for the earth, which was actually the first ecocentric instrument that was adopted by the General Assembly with 111 votes. The UK voted in favor of this. And if you read that instrument, it's a fabulous thing. It's really, really, I think, marked a direction that we should have taken. 10 years later, we had the Rio Declaration, which went back to the anthropocentric perspective. And I think now we are, and this is my experience as a litigator speaking, at a point where courts are starting to see the connection between the natural world and humans again. Because we have had a lot of decisions where we can see that we cannot distinguish that. We cannot separate that. So environmental law, I predicted that about 6 years ago, we are going to leave massive amount of environmental disputes in the next decade. That's what I said in a piece I wrote. And this is exactly what has happened. And I think we are in that trajectory still now.
And I think the book tells the story, because the chapters, the cases are roughly in chronological order. I know the first one is out of order, but apart from that,
yes.
You tell that story, and when I read it, I saw it as, the Torres Strait case is the attempt to bring an ecocentric approach into human rights law, right? The environment is changing, as you described. The islands are turning, the species are disappearing, and that is a violation of the islanders' human rights. Their human rights are affected by the changes to their environment.
Yes.
But it isn't until the Los Cedros case that you move beyond human rights completely.
Yes.
And you are actually enforcing the rights of nature itself. And could you tell us about that case? Because it's as an international lawyer, it's unusual because you were intervening in domestic proceedings, weren't you, in Ecuador?
Yes.
Under the Constitution of Ecuador.
Yes.
And that constitution is also a groundbreaking piece of law because it is the first one, you write, the first constitution that adopts a properly ecocentric approach. And I've got one very short, I promise, quote from it, Article 71, which says, "Nature, where life is reproduced and occurs, has the right to integral respect for its existence and for the maintenance and regeneration of its life cycles, structures, functions, and evolutionary processes." So nature is the rights holder.
Yes.
Could you tell us about that case and how you came to be involved in enforcing those rights on behalf of nature?
Yes. So you had this fantastic constitution, right, from 2008. And there had been already some cases at a lower level on rights of nature, in particular river. But the Constitutional Court had never decided on a case, and the Constitutional Court picked up that case. And it was a case that it was unremarkable in a certain sense because, you know, this is a story that happens in Latin America all the time and in many parts of the world all the time, which is that you have a wonderful forest threatened with a particular development. It happened that in this case, the development was a gold mine and the forest was one that had a lot of endemic species. The closeness to the Equator line meant that this place was a very special place when it came to biodiversity. Now, how I became involved was really as an amicus curiae, which is really a role where you, as a lawyer, present an independent analysis of the law to assist the court in the determination of the case. So when I got the papers, I was invited to be an amicus. When I received the papers, I realized I was looking for some people around, or I was trying to find whether there were communities that would be affected by this mining project, etc. And I didn't see anyone in the forest as population that could be affected. So really it was just the forest. And then I looked into the forest and I started identifying all the species. And then it started really a fascinating journey because I will never forget, it was really during COVID. So I was really immersed into that forest. I mean, it was my world for a couple of weeks. And I started really diving into the reality of the orcas or of the, you know, the monkeys or the bear, the Paddington bear or the Andean bears, as we know that, these species over there, and understanding that they were very fragile and that really these species were disappearing. So basically in that little forest, in a little space like this, you could find a species that you couldn't find anywhere else in the world, and that really touched me. So it is with marvel that I realized that I was acting really on behalf of nature itself, and that my role was to put this in front of the court to explain what was at stake here. And that was fascinating because I used all the international law I knew to argue the case for the forest, for nature. And what was peculiar about the case is that you may say, well, but there was a constitution already, so why is it that it was not already protected? But you know how the law is. You know, everything has to be defined properly. So this was not a forest that had been designated as to attracting that level of protection. So it's like, you know, certain places you can, okay, that's all right to maybe to develop or etc. So the role was to say, although it's not, it doesn't matter what defines the need for protection was the actual identity of the forest. So my role was to bring together all what the scientists have done and present that to the court and with an analysis of the law and say, this is unique and it's got an identity that the court had to recognize. And the court said yes, eventually, which was a great, great moment. I thought, I didn't know that we will win. You just do your best. But, and the hearing was really surreal. It was really surreal because it was like 10 hours, so many parties involved, and the mining company was there, obviously, Cornerstones was there, and the state was there. They were presenting their position very clearly. And also, they were threatening Ecuador with an arbitration if their investment was to be affected, with a decision that said no. And I felt great that I'm very well acquainted with arbitration. So, this was a constitution is obviously the type of law that you have to take into account to do your due diligence before you actually go and invest. So how on earth do you want to go anywhere and say, well, actually I can walk on top of the constitution, that doesn't matter. So it was quite interesting that all these different levels of law had to come together. It was not a naive court. It was not a conversation that was isolated from a reality and realpolitik. No, it was a conversation that was taking place, a dispute in court for nature, had been completely aware of all what was at stake. So I thought it was wonderful. Yeah.
I thought that was a very telling point. You tell it in the book when, in the hearing, Cornerstone, rather than engaging with the legal question under domestic law, international law, instead said, well, if the court finds against us, we're going to take this to an international tribunal and file a claim against the state.
Yes.
And I checked, and they have not made good on that threat to this day. So your rebuttal was effective.
My rebuttal was effective. Certainly they would have lost. It was, I think that these are the realities when it comes to protecting biodiversity. And I have felt quite privileged to come to this area with the practice, if you want, that understand those other worlds as well, and how the law at the end of the day is quite integrated. So this morning I was at 4 a.m. I confess I woke up today at 4 a.m. I was drafting something which is going to be part of a book in honor of a judge that passed away not long ago from the ICJ. And one of the things that I was reviewing was the writings of a very famous scholar and diplomat, and the father, really, of international law, Grotius. And Grotius really, in his foundational book about war and peace, conceived law as systemic. It's a system. And I think that vision has accompanied me throughout all my career. And I think, in my own perspective, I don't think that there is a contradiction when it comes to commercial law or investment law or environmental law. There is a unity, and there can only be one rule of law. So it's not that this can be right here and wrong here, depending on the lens, but rather how do you combine all these different interests, and what is the answer that the law is given to that problem. And I think this is precisely what I've been doing with my work, looking at what is the solution.
Bringing that
Yes.
integrative approach.
Absolutely.
So far we've been talking about substantive law and how that has evolved. I'd like to also touch on procedural law, and that might sound dry, but it goes back to the discussion from the 70s, should trees have standing? And who can represent nature in a court of law? Now, you have been in such a court of law in the Los Cedros case.
Yes.
How was that question answered there?
So the constitution there is quite clear. Anyone could bring the case of nature. to courts. But in that particular case was brought by the local government, so by the, you could say, the equivalent of council here. That was the beginning of the case at the lower level. But you can see that all parties, even parties that were amicus, participated, which shows that the voice of the forest was brought from different angles, including from the angles of the scientists. Now, there are obviously other forms how procedurally there has been representation of the voices of, I don't know, natural bodies like rivers, etc. Some of them have been via guardians or the system of guardianship. For example, the case of the Atrato River, which is interesting because in Colombia, there's no constitution that says nature has rights. But a particular court identified that that was the only way, so protecting the river was the only way to properly resolve the dispute. So people brought a case on behalf of their own human rights, but they were suffering a lot of heavy metal contamination, actually quite disturbing, because mercury had been, because of the mining around, had ended up in the water. The fish were contaminated, people were eating the fish, and it was massive. And then when they bring the case, they want the right to health, etc. And the court saw that the best way to finish with that problem was to protect the river. Because the moment that you protected the river, you had the quality of the water change, and the people could safely fish and eat the diet that they always had. So they developed that approach, and in the decision, in the judgment, they formed, not only that they said that the river has rights, and they use obviously some international law to argue that, but they basically said that they could form a guardianship system that could have a plan within 1 year to establish what was that plan. The guardians were formed by people living along the river, representatives, but also the state, and it could have a scientific advisory group as well. And it was all set up in that way with funding that the state had to put forward, and that they had to produce a plan for the river eventually to clean it up, et cetera, and the procedural rights also granted procedural rights to the river, because the river could go back to court in its own name. So I found that that was quite a leap when it came to, giving procedural rights. There has been other examples in Canada, concerning the Magpie River. A council has gone for an ordinance, and in the ordinance they have said this river has procedural rights as well. So it's very interesting how this is evolving. I'm acting on a case at present before the European Court of Human Rights, acting for a lagoon. Mm-hmm. And the lagoon is Spanish and is a legal person under Spanish law. And that particular piece of legislation, Article 6, grants any individual wanting to protect the lagoon the procedural right to bring it to a court. So any NGO, anybody could possibly bring that case to the court, and that's what happened in this case, and that's why we ended up now before the European Court of Human Rights. So I find it fascinating.
So that example shows that this is by no means a movement limited to Latin America or the Global South, broadly speaking, that the idea of recognizing the legal personhood of natural entities is a movement that has reached the global north.
Totally, and actually in a major way, because the highest example I had participated in was this Equatorian Constitutional Court proceedings. But this is happening before the European Court of Human Rights. And obviously, you may know that legal persons have legal standing in Strasbourg. And that is already been from the 70s, but what used to be is that the legal persons were usually corporations. So this is a test case because it's the first time that a natural body that is an acknowledged legal person is seeking redress before the Strasbourg court. And I think that is a huge test for Strasbourg, and I'm looking forward to arguing this case before the court.
Just so we can look it up, what's the case called? Or
It's called El Mar Menor.
Mar Menor.
Mar Menor versus Kingdom of Spain.
Thank you. We'll put those in the footnotes to this session. I'm mindful of time. I just want to ask you about the sort of elephant in the room, I guess, in the book, and it keeps coming back, is politics. Mm-hmm. You seem somewhat disillusioned with politics, and you write, it is clear to me, so you write that the Conference of the Parties, the climate change talks that happen every year, is a form of productive denial. A lot of busying around, but very few actual outcomes. And you write, it is clear to me that the changes have to come from the bottom upwards. Legal processes and litigation are part of that phenomenon. So I'd just like to ask you directly, how do you think this shift to an ecocentric legal system can come about?
Yeah, well, I don't think I am, I see law and politics, completely separate. So I don't consider myself disillusioned of political speech or the political environment. I think I am very much in agreement with Rosalie Higgins' perspective of law as a process, and that happens in a political context. So, and we know that we are always paying attention to policy. In fact, 1 year I was a legal advisor at the Foreign Commonwealth Office, and the great lesson for me was to see how the law applies in a political context. But what happened in particular with the Paris Agreement is a big limitation when you actually come to a stall because there is a diplomatic, I would say, lack of agreement in moving forward to an applicability of primary rules that have been agreed and adopted. So the question is, so you have a wonderful set of principles, but you don't have enforcement mechanisms. So what happens with that? Is it that we cannot do anything with that treaty? And my answer was, no, yes, we can. And then the big question was, do we interpret all treaties in a way that takes account of that new reality? And that's the path that I followed. And I think that why is it that the ordinary person is important here? Because the ordinary person was really experiencing the everyday. Perhaps, back then, when I started, it was the Inuits or the Torres Strait Islanders type of people. But, clearly, to me, this was going to be soon and fast a matter that we were all going to be worried about. I mean, if we think about water and how important water is, rivers, we know, are super important when it comes to combating climate change. Rivers in the UK are the rainforests of Britain. You could say it's the equivalent when you think about the rainforests in other parts of the world. So those are absolutely essential, let's say. And you have seen what has happened recently with water being really scarce in England. And we witnessed what happened in Sussex not long ago. I never thought that I would live a day in England where, a town, for example, would be deprived from water for 4 days. I have lived that in Lima, in Peru, and I knew how strong, the experience is for anyone that is. But it's happening because we are in a crisis, and people are starting to understand how valuable and important it is actually to protect the natural world. So basically, in other words, it is who are, on the front line, if you want to, understand all these changes are the ordinary people. And I think those are the cases that are coming to the fore, that are coming to change the law. Change the law in the sense really of helping to evolve, the law, because judges are just interpreting what is out there, but the principles are being applied in a context that is new. And ordinary people have a great role and power to actually be able to make these mechanisms, forcing these mechanisms to look at it and give a solution.
Thank you. I would like to take some questions now, if there are any in the room. Alex.
Monica, thank you so much. Law responds to the political environment and the social environment, as you said, and ordinary people are beginning to realize the value of the nature around them for themselves. I think if I try to badly encapsulate some of what you've said, where do you see the biggest opportunities for the law in driving change in the times that we're living in now?
Yes. I see a great role for lawyers. I think we are really extremely important in this process because people come with problems, but are lawyers the ones that have to look for solutions and who have to argue them in front of those who decide what the solutions should be. And so that's why I see a really, if you observe, when I started analyzing climate issues, environmental issues, and I started writing on this after this invitation for these arbitral organizations, this was 2015, the bar, to give you an example, climate change was nowhere to be seen at the bar. And in fact, even I don't recall having anything from law firms at the time, but how fast that has changed. I don't think right now there is one single chamber in London that doesn't claim to do climate law at some level. And so that shows really that this is a very live matter, and then lawyers have clearly a crucial role to contribute to. So I think that the opportunities are out there in the following way. Just like the time when the Human Rights Act emerged and was adopted, and then you have the whole subject of human rights being incorporated into English law. Wow, what a moment. All the different standards were developed. I think we are in a very similar moment, but in the area of environmental law. Environmental law started showing up in different international bodies, but now also at domestic level is being extremely relevant. And there's so many different types of disputes that we are seeing developing now, new standards, clarifying law. To take an example, environmental impact assessments. What a revolution. I mean, not long ago, it was conceived in certain ways. With the Finch case, we clearly saw how limited was the interpretation of what an environmental impact assessment, supposedly was to look at. And now we have a clarification from the Supreme Court. Well, that's one tiny example. But like that, there are many, many, many different areas. So I think what I see is an incredible moment that there is just so much to do when it comes to clarification of the law, redress, and that is both in the public law arena, is also in the area of private law. We are just seeing group litigation becoming a very important type of procedure in the UK. I act in group litigation. It's not an easy, light type of litigation, but when you see the outcomes of some of these cases, it can be just sweeping, and maybe very proud of our legal system in England because it is robust and it can deal with extremely complex cases. So I see really now, after the international courts have delivered these massive advisory opinions, a moment where, so what do we do with these principles that these courts have enunciated? How do we apply them here in the UK? And what, because the UK obviously have these obligations. Internationally, they already know that. So how does that translate into our domestic law here? Well, that's a sea of opportunity right now. And you know, I just see so much to do. So I think this is a big moment.
Monica, if I may, I'll ask a question from one of our online guests. So it's from Dorina, and she said, thank you very much for this session. As someone from a migrant background, I find your progression within the legal profession and your achievements particularly inspiring. In reflecting on your career development, may I ask what challenges you encountered and how you addressed them?
Yes, I think adaptation was is a key word, and I think for all of us it is. I think that when I studied law originally in Lima, I was always told I was not going to be a lawyer, I was a jurist. And apparently that was really about thinking as a lawyer rather than, you know, being comfortable just with one set of rules. And that was very true, and I realized that when I came to the common law, well, I loved the common law because, wow, it worked so well. And it was really exciting to see, it was like 100 years gap, you know, from seeing one system. And then 100 years later, you see another system that has evolved to this level, particularly procedural law. I was completely fascinated by civil law litigation in this country. So I guess, to me, it's very key to have that openness and to have that ability to adapt. And I think that that is a key for success in any field and innovation. So I was not scared of innovation. I was just telling you before how I was very respectful of these views that were, you know, the people that came before me that were quite well respected, very established, that they had certain views about the law. And I was a bit timid about, am I seeing things rightly here? I disagree. Well, at some point in my career, I realized that I have reached the maturity to actually stand my own ground and disagree with some people that maybe I respected, but I disagree with. And so to be courageous enough as an advocate, as a barrister, to actually present things in front of the court in the manner I understand them, I think that that is extremely important for an advocate, for a barrister to make a difference, and I think for the law. So we talk a lot about being fearless at the bar. Well, that I think is what fearless means. It means to be able to, without further considerations, just believe in the interpretation that you are given to the law and present that in an honest way before the court. So that would be my advice.
Thank you so much for a great talk and also the book. You already talked about the opportunities in law and also domestic law and the role of lawyers. I just wanted to drill a little bit into international law, public international law, something you've dedicated your career to, obviously. One hears a lot these days about the end of the international rules-based order and how everything is collapsing and we're back in an era of great power politics. What are your reflections on that? How do you see the international rules-based order, if there ever was such a thing, evolving? And what would you say to that?
Yes, thank you for the question. This morning, the proofs that I was reviewing was of a chapter I wrote in this book called "Is there such a thing as progress in international law?" That's the question I addressed. And I went really through all the development of law through the centuries in international law, and whether it has taken us to a moment where you could say, you know, is there such a thing, a continuous progress? I think that as someone that has come from a lawless, lack of enforcement of any, if you want, standards that have teeth, you know, I come from that. I come from experiences of a civil war. just like Grotius had experience of civil war, he wrote his book in the midst of that. I see the importance and the role of law and the rule of law, and what we have, limited and sometimes facing great challenges, it is something extremely valuable to protect. So I do think and agree with Grotius that ultimately the ultimate source of law is human consciousness. And to the extent that we as human beings consider the function of law, what law ultimately is serving is definitely to make humanity, and not just humanity, but the community within this planet, obviously viable. So anything that goes against that, I would say it goes against an important premise, that is the rule of law. So I have faith that as a humanity we don't want to destroy ourselves, and we have this amazing moment, because you see, don't forget that it's in great obscurity that the law has evolved. The law has never evolved when it was all very comfortable. It's in moments of great darkness that all of a sudden the law had to have a proper response for the future. And I think we are just living that very moment. And I think we are really, each of us is very capable to bring something to that. And that's why I think this is a big moment where it's not going to be just about humanity, it's going to be about a multi-species world, because our law is evolving. And I think I'm looking forward to see what we are going to achieve in the next years. But I mean, part of that is people that are in this room probably. So yes, that would be my answer to your question.
What a call to arms. I think there was one more question in the room.
Thank you so much. I had two questions, but I don't want to be too greedy. The first was just about the cover and the process that you went into with the book, because it is a beautiful book, so I'd love to hear about that. And then I'd love to hear about what you'd like us to do with this book to kind of follow on the call to arms conversation.
The process of the book was really very new, because usually, you know, when you write as a lawyer, you are not seen as a person. And this was a different type of book, because it was very personal. And maybe the idea was that, you know, to take the license of stepping away sometimes from the advocate, and then to start realizing that I was, you know, part of the problem. Maybe the chapter 1 puts that quite clearly, how I felt implicated. And this is precisely the kind of feelings and observations that made me want to discuss beyond the law. I didn't want to write a legal analysis. I wanted to involve you all and walk, perhaps give you a glimpse into this process where I was understanding things in a way that sometimes was rather surprising and shocking. Sometimes it made me angry. Sometimes, I mean, for example, seeing the rivers being diverted, I mean, it made me angry at some point. And yeah, I mean, also these emotional aspects of, I don't know, these big battles, and what you see is happening, and then there's a reaction, and there is also perhaps understandings that go beyond the law. There's a lot about literature here and philosophy. And I love that possibility to actually, you know, step out from the shoes of just a lawyer and being able to be human and non-human, because actually I was really getting the beyond human. I was getting into the shoes of a plant, or, you know, how a mushroom feel about this, or the point of view of this frog. And that was rather refreshing. So I enjoyed the process very much. It was really, really lovely. And I wrote sometimes, you know, I wrote it really in 2 months. Yeah, so, and I was sometimes writing the book at 4 a.m., you know, when everything was quiet and I could see my garden, and I was It was a very nice process, actually. I enjoyed it very much. I said, oh, I like to do this for a living, really. It's very nice. So I think I love books. I think books are a great window to a lot of interesting ideas. And I think we do have to engage with ideas. So it was a gift that I wanted to put out there. And I was very curious as to how people would engage with it. So I hope you like it.
And the second question, I think, was about the cover art.
Ooh, the cover.
Is that a question for Faber?
Yeah. So no, it was a little bit inspired by von Humboldt. So I mentioned von Humboldt in the book, and he was making some drawings during his visit to Ecuador. And there's a particular drawing of him and El Chimborazo at the back. So the back you can see here is a little bit, it follows a little bit that style. And this is a little bit a symbol, right? Because there are different, you can see here, I mean, some aspects of the Los Cedros, which has a lot of vegetation that is very similar, and a combination of different landscapes, you know, the Guatemalan landscape. It has a bit of the Amazon. I mean, I travel in the Amazon and I speak a little bit about my trips in the Amazon. That Amazon that I met doesn't exist anymore. So there's a lot of, I don't know whether nostalgia, but there is a sense of a world that it can go very fast if you don't act. And I think that's what maybe the cover was kind of trying to draw you into, you know, this natural world that could have a threat, you know, that can potentially affect it in an irreversible way. So that was the idea behind the images there. Yeah.
I think we've got time for one more question.
Thank you very much for the inspiring talk. I just have a specific question about rights of nature, because there's a lot of academic scholarship that critiques rights of nature as being maybe a bit individualistic and chopping up a very broader ecological question, and simulating a sort of level playing field between all the actors, like the communities, corporations, the state, etc. Do you think there is more to explore into rights of nature to bring it about? I was thinking about the Atrato case, because a long time after, the state hasn't still fulfilled all of its obligations because of also governance issues, right, within the government of Colombia. And do you think this should be coupled with other processes alongside rights of nature?
Yeah. So I think issues of, so to start with, I mean, I think it is it's a little bit, to actually need to talk about rights of nature is already showing something. You see, it's just similar to need to talk about human rights. It shows you already that there was a massive violation. And it's the same, because, you know, if you speak to indigenous peoples, they will tell you that they don't know what is nature, because they are within. So they don't need the concept. There's a lot of different languages from indigenous peoples. They don't have the word nature in that language. Certainly in Quechua, it doesn't exist. So it is our Western civilization that need that concept of nature. But, you know, because we need to protect it, we go along now having to name it in order to protect it. And to the extent that we understand that we are within, that you know, we are part of that. Otherwise, what are we? I mean, we are not a building. So we are made of organic matter. So we are part of it. Now, when it comes to enforcement, yes, I mean, these are the first instances of something new that is growing. But I think how fast this is moving is what you have to pay attention to. I mean, not long ago, the first insect has been given that protection. That is a stingless bee in the Amazon, in the Peruvian Amazon. To the extent that we are starting to culturally change our own minds and our own understanding, that's a huge step forward. Think about England. When I advised the River Ouse, which was not long ago, it was only the River Ouse. And maybe they were already considered a bit of natas, you know. What are they doing? Declaration of Rights of Rivers. Well, I mean, it's not that crazy. because it's not just about a declaration, for example, in the case of England. We worked for a couple of years with all the instruments that we could possibly advance an ecological perspective in. For example, there was no mentioning in some of the policy documents of anything to do with biodiversity, anything to do with the value of the river. The river was only mentioned when there were instances of flooding. So you start thinking, is this valuable for us, and in what way is valuable? And once you start changing all these soft law areas, you start creating a different framework. So it's not just one single instance. It is bigger than that. And I think it's reaching people very fast in England. I think there's about 4 or 5 different instances where councils have already made declarations of rivers. So to give you that example, what we are creating there is a new social contract. And at some point in England, it will arrive the moment to discuss that properly, the moment where there are so many constituencies that actually have affirmed those rights, that you will have to have a different type of conversation. So you see how complex it is, and it's not just about one specific measure that was complied or not complied. This is bigger than that. That's my perspective.
Monica, thank you. And what a great note to end on. It's a perfect illustration of the power of the law and the power of lawyers, not just in litigation, but also in their advisory work. Because this is an example of you advising a district council of Lewis in relation to the rights of the River Ouse. And so I think we can all take from this an opportunity to reflect about how we can bring the rights of nature into our own practice as lawyers, whether it's contract, whether it's public law, whether it's commercial law, and help edge along that shift to an ecocentric approach. So thank you again for joining the Academy, Monica.
My pleasure.
And please, can we have a warm round of applause?